All right, come on up, Mr. Smith. I can call Gregory Clinton Smith, 26 CR 1021. He appears out of custody here for a first appearance. And there's been one formal charge filed, Mr. Smith. And Ms. O'Rear will hand you a copy of that complaint information. So hang on to this. Mr. Smith, it's my understanding that you are not wanting to be represented by counsel.
Okay. How are you doing today, Your Honor?
Good, sir. How are you doing?
I'm doing well. First, let me ask, is this a court of record?
We are on the record.
Well, this is
And so you can see the FTR here is on, so
sounds good.
we are being
Okay.
recorded, yeah.
Your Honor, I am Gregory C. Smith Jr. I'm a natural person. I'm submit this notice to ensure that the record reflects my intent to comply with all lawful procedures while maintaining my constitutional standing. I appear in my proper person as a natural individual, and I'm here to facilitate the court's inquiry into the legal nexus of this matter. I invoke the protections of Article 2 of the Colorado Constitution and the 14th Amendment of the United States Constitution to ensure that these proceedings adhere to the highest standards of due process. I want to make a formal request of the court's assistance in protecting my liberty interest from the arbitrary actions of a private surety, which is my bondsman, who is threatening to interfere with my Sixth Amendment right to counsel and 14th Amendment right to liberty. I am motioning for the court for a preliminary hearing and discovery, and I filed notice of compliance and reservation of rights to, ensure that we, follow the 14th Amendment standard.
So just so I can make sure I'm addressing everything you're requesting.
Yes, ma'am.
So first, I cannot grant your request for a preliminary hearing because this type of case, it's a Class 6 felony called trespass of an inhabited dwelling. It does not qualify under the Colorado statute for a preliminary hearing out of custody. So I can't grant your request for a preliminary hearing. Regarding discovery. Discovery is something that you request through the district attorney's office. I actually don't have any of this discovery in your case because it's not the court that's filing this charge in your case. It's the district attorney's office.
Okay.
So you have to go through the formal process of requesting discovery through their office. Okay, keep going.
Okay. I just want to also make a note on the record that I'm appearing specially and not generally in behalf of this matter. I have filed with the district attorney's office and with the clerk of court a number of motions, which.
And I don't see any of those in your file yet. When did you file them? Just before court?
Well, it was before court, and I'd say it's probably been some hours now.
Okay, it maybe just hasn't gone through processing.
No
it
problem.
takes a little
No
bit, so I don't see any of those motions. Okay, go ahead.
I do have copies and a certificate of service that I have with the.
If you file them with the clerk, they will get to the district attorney's office. We can't file anything here for you. That's why you have to do it through the clerk's office. And it sounds like you did that earlier.
I just want to note for the record that I filed a number of motions and notices through both the district attorney's office and the clerk of court.
Okay.
Okay.
All right. So Mr. Smith, I apologize. There's been a 1-count complaint and information filed in your case. What my question was to you earlier is if you're going to get hire counsel or apply for the public defender's office.
Neither. I'm going to go pro se on the matter, ma'am.
Okay.
And I wanted to address the bond concern as well.
And you had mentioned that your bondsman is impeding on your right to get counsel. I'm not sure.
So this is the situation. Me and him have made an agreement, and he has reneged on he is attempting to renege on the agreement. And because it's a private commercial matter between me and him, wherein he got me out. We agreed that I would pay him.
Mm-hmm.
However, he has moved the date of payment up where I'm not able to, in fact, possibly pay him on that day, and he's threatening to revoke my bond.
So unfortunately, I don't have any control over your bondsman. It's
Understood.
their right to agree, to make any agreements, and I'm sorry that there was, it sounds like an original agreement and that has since changed regarding the date of payment.
Mhm.
But ultimately, your bondsman at any time can determine that they no longer want to stay on your bond. And there's nothing I can
Well, I'm
do
just,
to
I'm
prevent
moving
that.
for an emergency motion to grant a PR bond. And so I can continue to represent
Okay.
myself pro se and.
Let me ask the district attorney
Sure,
and we can
sure.
address that. So right now, I'm sorry. I keep saying Mr. Peoples, I mean Mr. Smith.
Mr.
I
Smith.
apologize. Mr. Smith is currently on a $3,000 surety bond. This is a Victims' Rights Act matter, so I don't know that we're able to address converting that bond to a personal recognizance bond today, but I'll ask Ms. O'Rear to address that.
Before you, let me just add that.
No, I'm gonna let her answer my question first, Mr. Smith. Thank you.
That's-
Okay.
Yes, Your Honor, because this was a Victim Rights Act case, the people were not put on notice to address bond as it was addressed at the last court date. Therefore, the people cannot address bond today.
And so because of that, Mr. Smith, I cannot address bond today, but I can set another court date for us to do that. But
Okay.
I'm unable to address bond today.
I just want to note that I'm not a flight risk. I'm here today. I'm actually.
So we would address that at a bond
At the
hearing,
bond
which I
hearing.
can't have
No
today.
No problem.
Okay, so it sounds like we need to address bond. I can set that, any objection to setting a bond hearing next Monday, Ms. O'Rear?
Objection, Your Honor.
So I can set a bond hearing in here next Monday. That's going to be March 16th at this same time, 3 p.m. in Division DST, the same courtroom with me. And that's to address the possibility of converting this current bond to a personal recognizance bond. I don't know what the outcome of that will be, Mr. Smith, so do continue to work with your bondsman or look into another bondsman if that's something you need to do.
I'm going to attempt to.
Okay, and then as far as you electing to go pro se, it sounds like you're pretty set on that. But I do want to just give you sort of my 2 cents. First, a question for you. Do you have any legal training or experience?
Let me ask why you're asking that. I mean,
It's just
just
part of my advisement because I need some answers to these questions to give you some information. So have you gone to law school? Have you ever gone to school to study the law, specifically criminal law?
not specifically, no, ma'am.
Okay. And I just say that because the law is obviously very, very broad.
Yeah.
Criminal law is pretty hefty. I know I've spent years practicing it. I know other people have spent years practicing it, and I still come across issues all the time that I don't know
Right,
and questions
right.
that I don't know the answer to.
Right.
And so I ask you this because you don't, having an attorney doesn't mean that you have to do everything that they advise you to do. You still get to make decisions about whether you want to go to trial, take a plea,
Right.
things like that.
Right.
Of course, your attorney, you can't just tell them, do this, do that. I mean, obviously there's things they have control over as well. But even the basic part about getting discovery in your case
Mhm.
can be really difficult for a person that doesn't have any legal training, whereas lawyers do, from the public defender's office and private attorneys do it all the time. I always give the example of like nowadays we have so much technology, there's body camera footage, there's surveillance. And sometimes you get this discovery, you may not even have the computer programs that can run that software so you can watch the videos and things like that. And so just like the technological part of getting through that, you have an attorney, they'll get all that through for you. You'll be able to see all the video, photos. So even that basic step, things like requesting a preliminary hearing and knowing why your case may qualify or not, but what other motions you might be able to file in lieu of not being able to have a preliminary hearing, all of those things. And so I think that I understand why a lot of people want to go pro se, but I think having an attorney to help you at least be advised first and know how to do some of these things. And, at the end of the day, if you determine you want to continue going pro se, or you only want advisory counsel, or you do want to stick with your attorney, you're giving yourself more options.
Okay.
And you're better positioning yourself for a defense in your case. And it sounds like to me, without you having to express it, you feel very strongly about potentially having a defense in your case, which most people do. So my thoughts today, if you'd like to go this route, are that I would see you next Monday for a bond hearing. And in the meantime, you would apply for the public defender's office to just see if you qualify for their services. And then I could also give you a resource for private attorneys to reach out and start calling them. But at the very least, seeing about getting an attorney on your case, at least in the beginning, to see if that's something you want to explore. Just sitting down to talk to someone and go over the discovery in your case can be really helpful
Okay.
when you've never navigated the system. Additionally, every jurisdiction in Colorado is different. So I've practiced for most of my career in Colorado Springs, in El Paso County, but I've also practiced in other jurisdictions. They're all different. It's all different how the district attorney's office works and how the courts work. So it's more than just, it's just, there's a lot to it.
Trust me, in the reading over the years, relating specifically to Colorado court procedure, federal court procedure as well, and the Colorado revised statutes, you are absolutely correct. It is hefty. Unfortunately, I just haven't had the best experience in dealing with public defenders,
Sure.
and even with judges and being represented by the public defender's office. And so I would definitely take your advice and your suggestion under consideration.
Come on up, sir. This is 26 CR 1021. Mr. Smith was set today for a hearing on bond and an appearance of counsel. Mr. Smith, did you get that public defender application turned in?
I have not yet, ma'am. I'm non-domiciled to the state of Colorado. I came out here for business, even though I have family and some other matters set up out here. There's a lot going on, especially with this happening. So I just haven't been able to do it yet.
It sounds like
They
you're
wanna address-
currently employed.
I'm sorry.
Or it sounds like you're currently employed. I can't remember from our.
Yes, ma'am.
Do you have proof of income that you can pull up on your phone or anything, like pay stubs or anything that you could show? Because the public defender's office is looking at your past 4 weeks of income to determine if you qualify for their services. So I'm trying to see if we could get you qualified for the public defender's office today.
Oh, okay. And we're also addressing bond. Is that correct?
Mhm.
Okay. Can we do that now?
Sure. I really wanted you to have an attorney on board to help you with that, which is why I'm asking about that
To
application.
help you with
first.
bond?
To help you address bond today, to help make a bond argument today.
Well, I can make a bond argument if that's the case.
Okay.
I
So
think
Mr. Hoffman, we're here for a bond hearing as well for Mr. Smith. He's currently on a bond. He had posted a $3,000 surety bond. And we're addressing bond today because he's asking for the court to issue a personal recognizance bond. So I'll go ahead, Mr. Smith.
Well, I'm asking, this is an emergency request in lieu of a dispute between myself and the bondsman. And so my only, I guess, qualm is that because I'm looking at going pro se, and I've appeared at the last meeting, and this one here, I'm not a flight risk. I've already have made preparations to stay to get this matter situated, but I do need some leeway to be able to do my investigations and so on and so forth. And so, and I also have matters back in my home state to take care as well. So I need to be able to address my business while I'm here. And so that's why I'm requesting a PR, and it'll relieve Mr. Woods of his responsibility and obligation, and we can be, me and him can be settled, and we can go from there.
Okay.
So I have ties to the community. Been out here since 2008. And again, I had a last court appearance. I spoke with you, and I'm here today to, address this matter as well. So
Okay, Mr. Hoffman, what's the people's position?
Your Honor, the people's position is that bond is appropriately set. We note that the victim strongly objects to any modification of bond. She has extreme fear for her safety. The facts alleged also indicate the defendant having issues abiding by court orders and law enforcement orders. There's also a fairly extensive criminal history here. I would also note in 2015, 1 failure to comply, 2 failures to appear. In 2016, 6 failures to comply and 7 failures to appear. In 2025, failures to comply, and in 2021, 3 failures to comply. So bond is appropriately set, is the position of the people.
Okay,
Ma'am, may I say something in regards to,
sure.
due to the nature of this incident, there was no physical hurt.
And I don't want you to talk about the facts of your case.
No, I was just, only thing I was going to say is
Yeah.
that in lieu of the charge, there is a presumption of innocence. There was no hurt, harm, threat to anyone. And so I'm not at the residence. I have no intention on going back to the residence, at least until this is resolved, or I can have a keep the peace order to retrieve my belongings. But there's no threat to myself. There's no threat to the community here.
Okay, all right, thank you, Mr. Smith. 1 second.
Again, I'm just, under the 14th
Please, second.
Amendment. Oh, yes,
Just 1
ma'am. I'm
second.
sorry. I apologize.
So Mr. Smith, I just wanted to re-review the probable cause affidavit in this case. So I'm looking just kind of at your criminal history, which is, there's a history here that you have in Colorado, and I know it sounds like this may not be your main state of living anymore, but it does look like there's a lengthy record in Colorado where there's been some criminal cases filed over the years, and I haven't been able to look.
Yeah,
Through-
they've been settled. Those cases have been settled, ma'am.
Yeah, I'm just saying that there is a history. And I also reviewed the protection order that is part of this case now. That
Which was for
issued.
the son, and he wasn't there.
No, a different case. I'm looking at the
I have a protection order against
One.
the,
that's 25 CR 612. So I was looking at that one, and that's a civil protection order. That's now a part of this case. And again, I don't.
I'm sorry,
No.
say that again now? There's a civil protection order.
5C 612.
Do you have the
I'm
right?
looking at that, and that's what's a part of this case. So
25 CR2 is part of this case? Is that what you're saying?
25C 612. That was a protection order issued in El Paso County on March 5th of 2025.
And who does that?
So this is a civil protection order. And it looks like it involves a Maudlin Broadbelt. And
Her
it's
son,
like-
yes, that's the son. And he wasn't there. He's in school. He wasn't there during the time that of this.
I think you need to get a copy of that protection order and take a look at what is included on that protection order as far as restrictions.
Right, that's,
Um,
should not go back to the residents and
So-
from my understanding.
So anyway,
as well.
back to bond, Mr. Smith.
That was
So given-
25, before, that was 25 CR what?
It's just 25C
Mm-hmm.
612.
Oh,
25C
612, okay.
So given my review of the probable cause affidavit and the Colorado history, I'm not going to grant a personal recognizance bond at this time, Mr. Smith. I'm going to leave bond set at the amount that it is. And I'll let you continue to work with your bondsman or see about a different agreement or a different bondsman. But for now, the bond that the 3,000 surety bond that you posted with Mr. Wood is going to remain. And I'll have to let the two of you kind of figure out what you're going to do moving forward. Okay.
Can I request the CUSIP number for that bond, please?
I don't know if that's something that I have. What I could pull up is your appearance bond paperwork, and I could print you a copy of that. That might have what you're looking for, but I'm not sure about that number. It gives you the bond number. Is that what you're looking for? I'm
I
just
think
happy.
it's say,
All that I have that I can do is print out your appearance
Okay,
bond
okay,
paperwork.
and
So I'll
I'll
print that out
accept
for you.
All right.
So Mr. Smith, do you still want time to see about applying for the public defender's office? I think
Yes,
it would be
yes.
incredibly helpful for you to talk to an attorney.
I think right now, what's more important to me is the issue with the bond.
Well, I've made my decision for today regarding that.
No
So
problem.
that bond is going to stay as it is, and you just have to work with Mr. Wood.
Will I be able to readdress it at another appearance?
Not in here. I'm not going to readdress the issue of bond because I made my decision in here. So I can give you another week to apply for the public defender's office, or you can go and try and do it right now down the hall. You've got about 30 minutes.
Yeah, can we do it within 30 days?
I'm not going to give you that much time to apply for the public defender's office because it doesn't take that long. So I can save you a trip from coming back to see me next week, and you can go and try and do it right now, which I think makes
No,
sense.
that's not going to happen. I'm under time constraints. Like I said, I came out here on business, and
If you're under
this-
time constraints, it kind of sounds that applying for the public defender's office sooner than later makes more sense.
Right. If you recall at the last hearing, I'm more leaning towards pro se, and so.
Is that what you want to do today? Is you want to go pro se? I'm happy to give you some more time to apply for the public defender's office. I can
Okay.
set you over a week. Like I talked to you before,
Mhm.
right? This is just the beginning of everything. You can elect to go pro se down the road. You could hire a private attorney if you wanted. But seeing if you qualify at least initially for the public defender's office, get to meet with an attorney, get your discovery in your case so you can go over all that. I think that would be really helpful for you, at least initially. And you can always change your mind and decide, I don't want an attorney to represent me. I can represent myself. But I think at least initially, it's going to help you out a lot because I'm looking, you filed a certificate of service. This filing is not helpful. There's not much I can do with it today, given what you've, I think, advised that you filed. And I think you need, someone can help you with this. Someone can help you make these filings in a way that is more helpful to your case. Because they'll have the legal knowledge of how and when to file these and what's appropriate and the timing and all of those things.
I just figured to get it in early since I was made abreast and I was close to a library at the time. So I said I'd use the time to, make my notices and
Some of these
motions.
just aren't really applicable. And
Can you tell me specifically which
No,
ones?
because
No?
I'm not-
Okay,
because I'm not your attorney.
I
and can't
understand,
keep
I
you
understand.
waiting, and I'm not going to
I
do that
understand.
today. But, like your motion to quash, I think you're wanting a motion to dismiss. Like that needs to be filed in a different way and a hearing requested. An attorney can help you with all this. It sounds like you've got a good idea of some defenses that you may have, but you need an attorney who knows how to put that together and argue that for you. And even down the road, if you don't want to take their advice or you want to represent yourself, you can do that. But initially, right now, by looking at this, you really need an attorney to help you so that if you've strongly believe you've got a good defense here, someone can help you put that together that has the legal expertise, that practices in this courthouse,
Mhm.
that works with this district attorney's office, that can help you fashion these arguments. So do you want to go down the hallway and apply for the public defender's office right now?
No,
See if-
no, I'm on time constraints. I'm trying
Okay,
to manage
do you
my
want
business
me-
here.
Do you want me to
and
give
manage
you
my
another
business
week
and-
to do
Yes, ma'am.
that?
Yes, ma'am.
Okay, I'm
I
going to have
appreciate
you
it.
back here for a final appearance of counsel next week. That's going to be Monday, March 23rd at this same time, 3 p.m. in this courtroom with me, Division DST Room 170. And do you need to take another application with you?
No, ma'am.
Okay, you've got one. Do you know where to go to turn that in before your next court date?
Where?
Okay.
Okay,
So that's
okay.
the address there.
I got it here.
Is that building over
Thank you.
All right, we'll see you next Monday. All right, I'm going to call Gregory Smith. Yes. Come on up, Mr. Smith, 26 CR 1021. He's here for an appearance of counsel. And Mr. Smith, did you decide to apply for the public defender's office or no?
Hello, how are you doing today?
Thanks, how are you?
I'm doing well. Again, I appear especially and strictly as interested party. I reserve all rights under UCC 1-308, and I move for standby counsel to assist in auditing the Rule 11 defaults of the prior hearing.
Okay, so Mr. Smith, we're here for an appearance of counsel. Did you decide that you're going to apply for the public defender's office, or you want the court to appoint advisory counsel, or that you'd
Standby
like,
counsel.
or you'd like
And
to
also wanted
represent?
to address the bond issue.
We addressed bond last week. I denied giving you a personal recognizance bond. We're not addressing bond today.
You do understand, though, that the district attorney's office has dropped the VPO. There is no violation of protection, or they only filed a
Class 6.
Class 6 trespassing
I
charge.
did see that, yeah.
Okay, so there's no criminal element there. There was no, and then
A Class 6 felony of trespass is a criminal charge, so there is
right,
a
but the
criminal
underlying
element.
was the violation of the
I'm
protection.
not addressing bond today, Mr. Smith. The only thing we're here for is an appearance of counsel. So, Mr. Smith, do you want to represent yourself, or do you want the court to appoint advisory counsel?
Also, I requested the CUSIP number for the bond as well.
I don't have that. What I gave you last time was your appearance bond paperwork. And that's all the information I have about your bond. That information has Mr. Wood's information, his bonding number on that, the bond number of your bond. I don't have any other
Okay.
numbers to provide you, and I gave that to you last time.
So I move, if that is the case, I demand the chief judge directive number that authorizes a magistrate to preside over a constitutional challenge regarding a Rule 11 violation. Also, I accept the court's offer of bond for value, and I demand the CUSIP and the 1099-OID to ensure the beneficiary, myself, is credited for the use of his private exemption or credit. Also, to ensure the clean hands doctrine of this court, I'm moving for a stay of proceedings until the prosecution produces the CUSIP number for the $3,000 bond held in the registry, the receipt number of the district attorney's file security bond per CRS 20-1-101, and proof of standing for the non-owner resident to exclude a protected party.
Okay, so that's a lot of things you want me to address. None of this is filed in a motion.
Filed all of this in a motion already, and I filed special
You
appearances. as well.
filed a certificate of service, Mr. Smith, which provided none of the information you just read. Affidavit of fact you want, emergency motion, notice of intent, motion for directed verdict.
A motion to
affidavit
quash
of
for lack
in
of,
support of motion,
yeah.
omnibus motion, and that's it. And there's no other information. So
So you don't have a notice of special appearance?
all I have is a certificate of service for what I just read to you.
Do you have a request for the CUSIP number? All of this, I've
No.
asked for this all on record. We are on record, aren't we?
Yes, and so
Okay.
I don't have any of that information for you. What I can tell you is that there's been one charge filed. Your case is moving forward to the next division, which is Division 12 with Judge Findorf. Today, we're here for an appearance of counsel, and that's all I'm addressing. It sounds like you want to represent yourself, but you want advisory counsel. Is that correct? Yes or
I'm
no?
requesting standby counsel to
Okay.
address the Rule 11 violation.
Okay, so not asking for advisory counsel, but wants that on standby when you decide you
Well, so
want
they
it.
can file the appropriate paperwork, but
So advisory counsel isn't going to file anything for you?
that's what I'm requesting. Is
Then you need an attorney. No. So I can't appoint standby counsel. If you want to represent yourself, I can appoint advisory counsel. They're not going to file
what does
anything for you.
advisory counsel consist of?
That's a good question, and they would be more able to tell you of that. But the basic role is that they let you represent yourself, but if you have questions regarding legal issues or procedures, they can advise you on what the law says and what you can or can't do, but they're not going to file anything.
Do I give up any of my rights having this counsel that you're referencing, ma'am?
No, and you don't give up any of your rights having an attorney represent you either.
Well, they work for the court first and an advocate for me second. So that's a fact of
I
the
understand
matter.
that's your opinion.
No, that's
Okay,
a fact.
so you want to represent yourself at this point, right?
I told you what I wanted. I want advisory counsel or the counsel that you're referencing where it doesn't include me conceding any of my rights.
Okay, so I will appoint advisory counsel for Mr. Gregory Smith today. And we'll let Division 10 know that. And I'll note that Mr. Smith is electing to represent himself, but would like the assistance of advisory
Also
counsel.
that I'm requesting the oaths of offices from everyone and the CUSIP number for the bond. Since you're denying my bond,
I
I'm
don't
fight with.
have a CUSIP number for the
Okay,
bond.
okay.
I don't have everybody else's oath of office.
Well,
so
that's what
you
I'm
can-
requiring to be able to proceed with this if I'm going to
Okay,
represent.
and I'll
myself
let
intelligently.
Division 12 handle your motions going forward, okay?
All
So
right.
I'm going to give you another court date in Division 12. That's going to be on Wednesday, April 22nd
April 22nd.
at 9 a.m. in the morning, and that's for an arraignment in Division 12. We'll let them know about the
What
appointment
time was it again, ma'am?
at 9 a.m.
9 a.m.
and we'll let them know about the appointment of advisory counsel at that time.
Thank you very much, Sean. You have a good one.
All right, you as well.